Right, it's good. Starting recording. Hello, everyone, and welcome to our webinar on navigating the intersection of law and competitive intelligence. This Fireside chat is hosted by Proactive Worldwide, one of the world's leading market intelligence companies, helping top-tier organizations understand vulnerabilities and better predict market shifts and plan for growth with confidence. Our customized primary CI and VOC research projects and strategic war games deliver insights that impact leadership's mission-critical decisions. This session today is led by David Kalinowski, president and co-founder of Proactive Worldwide, and Richard Horowitz, an attorney based in New York that concentrates in corporate, international, and security matters, and who is a recognized expert in the areas of competitive intelligence, fraud, and international investigations. While there will be a Q&A session at the end, please use the chat function to pose questions you may have during the session. David?
Awesome. Thank you very much, Whitman. So good morning, good afternoon, good evening to everybody, depending on where you are or when you might be watching this. We will be making a copy of the recording available in the next couple of days. So we'll send you a link to that as well. So I'm really excited to have Richard here with us. You know, Richard and I go way back. Our firm started in 1995, and the next year, the Economic Espionage Act of 96 came out, and there was all this panic, that hit the market, and really all that ultimately did was, take stealing trade secrets, to a federal level. And if you weren't doing anything wrong before, you don't have to worry about that law affecting you now that it was a federal law, and it did impose and does impose some strict penalties if you violate that, right? $10 million in fine and up to 10 years in imprisonment. But there was a lot of concern that the Justice Department was coming after the CI industry, which wasn't the case. And so in 1998 in Atlanta, Skip had put on an event, and Richard was on the podium. I said, I got to meet this guy. So 25 years later, Richard, we're still interacting.
That's correct. Yeah.
So Richard wanted, I think most people probably are aware of myself and the firm. I've been involved in CI now for about 70,000 hours of my life, about 33 years. And I thought this was an important topic for us to address. There's a lot of conversations going on about ethics, and we all have our positions on those, and our companies have our clear guidelines, but there isn't as much conversation about the law. And usually the ethical guidelines can be much more strict than the legal guidelines. So today we thought we'd talk about that. So Richard, you want to introduce yourself a little bit more as well, and then I'll share a couple objectives, and then I'll turn it back to you to give us an overview on some areas, and then we're really going to get into about 10, 12, 15 questions to share with the group here.
Right. Well, I'm an attorney, and at the time, several months after Skip had after the economic espionage was enacted, 3 months later or 4 months later, Skip had a conference on the effects of this law, on this new statute on CI. Now, I had been a private investigator before being a lawyer, so I understood certain investigative techniques and the legalities of it. And at that conference, I heard lawyers saying all sorts of things about new risks and new prohibited activities, and you need to hire us, you're going to jail, and so forth. And I spoke the next day, and I said just the opposite, that the new federal law doesn't change anything that was or was not legal beforehand, because beforehand there was state civil law that applied, and what the federal law did was give jurisdiction to federal agencies to investigate and prosecute economic espionage, but it didn't change what it was that you couldn't do. Because, and one of the arguments I used was companies that say we've overhauled our legal guidelines in light of this new law are in fact saying beforehand they weren't doing things legally to begin with, because what wasn't legal or was legal didn't change. The difference was, before the EEA of 96, had you stolen or misappropriated a trade secret, you'd face state civil liability. After the EEA, if you did the same thing, you would face state civil liability and possible federal criminal liability. So the effect of doing that illegality changed, but what was or wasn't illegal didn't change. And I realized from the reactions I got from people who were CI professionals who heard me speak, that they were very concerned about whether what they're doing is legal or not. I mean, concerns that were misplaced. So I started to get involved. I published an article, and I started getting invited to these conferences and ended up debating people who don't agree with me. And
you don't want to do that against Richard.
You've been to some of them, and those I debated somehow disappeared from the scene, and I'm still here. And you've attended those back then, so you remember what it was like. And so what I want to accomplish first and foremost is to explain the basic underlying law that applies to CEI and correct a very big misapprehension about whether you can acquire trade secrets and what improper means are, because we're speaking now of the legal aspect, not of the ethical aspect. That's a different issue, which we may touch upon. But in terms of the legal aspect, what trade secret law and the economic espionage and another one or two laws out there prohibit is someone from using improper means to acquire a trade secret.
So Richard, let me pause right there for a quick second. So before you get into that, so as you guys could tell, Richard's really passionate about this topic, and at the end, we'll give you a website of his to go to, because you'll get articles you could download that he's written the definitive policy statement for Skip on the point of view relative to things like the Economic Espionage Act. And then he wrote about it about, 8 or 10 years later, because the people still weren't getting it. So I'll direct you to a site, because there's some great pieces to get on there to share with your legal counsel. So again, what we really want to accomplish today is giving you an understanding of the legal aspects related to CI. We want to talk about those risks that might exist, which are very, very, very minor, in my opinion, and likely in Richard's, assuming you are playing by the right rules. And of course, Richard and I are then going to have some banter back and forth with a bunch of questions that I know from over my 30 plus years of being in this industry, I get faced a lot with, and I'm sure other CI solution providers and other CI practitioners inside your companies get hit with. So we're going to address a lot of those very common questions, and again, be able to get Richard's view. Do have a quick poll for everybody, just to make sure those are out there are paying attention. If you can answer this question, how familiar are you with the legal, not the ethical, but the legal aspects of CI and the law? Take a moment, please look up from your computer, stop multitasking, and take a look, answer this question for us, if you would, please. Those that are more seasoned out there, I would expect to have a greater familiarity. And if you're relatively newer to CI, you probably don't have a great handle on the legal aspects of CI, other than what your legal department may have shared. So we got a couple more people. Let's try to get a few more people to respond. So take a look up at your screen, get a couple more responses. See if we get at least an 80% response rate, around 70. So give it another 30 seconds here or less. Whitman, let's go ahead and close that poll so we can share those results. So as you can see, about 65% are somewhat familiar, another 15. So we got about 80% of you that are not as familiar or somewhat familiar. And we have a good old 20% that are very familiar. So that's great to hear as well. So you could click on the X to get that poll off your screen as well. So just a couple quick disclaimers here as well. Neither Richard nor myself today are giving any legal advice of any sort. We are sharing our opinions, our point of views. We have over 60 years of combined experience dealing with issues related to CI and the law. And so we'll share our perspectives. If you do want formal legal advice, please make sure to reach out to your legal counsel. Do what they say to do, regardless of what you may hear during this call, and we'll probably emphasize that again throughout this session. Even if you disagree, even if you think they're too conservative, you have to do what your code of conduct requires inside your company, period. So don't be going and say, well, David and Richard said, that's not how this is going to work. So always adhere to what your legal counsel has to say. But if you do want to have your legal counsel talk with an attorney who is an expert on this, who can bring another point of view, please have them contact Richard. He is awesome, and he will help enlighten them a bit more about the concerns that they have. We have a lot of risk-averse attorneys out there. So Richard will help to point out the realities of this space. So again, we'll share his contact information again at the end. So Richard, I'll turn it back to you to just give a few minutes here. I know you wanted to share some overview, some foundation relative to the law, and then we're going to get into some Q&A with each other.
Okay, here's the main issue that confuses people. Is it legal to acquire another company's trade secrets? Now, most of the time when CI practitioners do the work, they rarely come across actual trade secrets, right? The famous hypothetical about finding a trade secret document in the street and whether or not you're allowed to use it, right? And theoretically, you can use it because if it's in the street, then the information holder didn't take reasonable precautions to protect it. In real life, I don't believe that's ever happened. I've never heard of it happening. Since I've been involved with this, I've been walking down streets all the time looking for trade secrets. I haven't found any. So those sort of things don't happen. The next big question is, what if I'm talking to someone and he tells me trade secrets? And in reality, that also doesn't happen. Because generally speaking, if it's not generally speaking, you can expect that if the person you're calling has confidential information, then he's not going to give it to you just because you ask him a question, what can you tell me about your company? Right? Those kind of questions don't induce the person to breach his duty of confidentiality, which is really what it is that crosses the line. So I never liked the idea gray zone, because what crosses the line of these things is if you induce someone to breach his confidentiality. And if you just call up and say, I'm interested in your product, what do you have to tell me? You're not going to get trade secrets. That's highly unlikely. And it's not as if it's an inducement that generates a breach. It's a question eliciting an answer. So and
of course, Richard, they're free to hang up or not answer the question if they don't want to, if they're concerned about it. But I would suspect that if you're talking to a senior VP of sales and you want to understand their go-to-market strategy, and they start telling you their strategy or their pricing information, that if anybody would know what not to share, it would be the senior VP of sales, right? So you have to is it correct to presume that it must not be confidential? Why? Because you're telling me.
That's exactly right. It's correct to presume that. In other words, I've never heard of a case of someone calling up and say, what can you tell me about my project? And the person answering, here are some of our trade secrets, enjoy. So that doesn't really happen. So the confusion around this question lies in the fact that people assume that once something is declared a trade secret, you can't acquire it. And that's false. You're allowed to acquire another company's trade secret if all the means you used in that process were themselves legal. And I'll show you in some legal documents that support that. So companies that say things like, we respect our competitors' trade secrets. I don't know why. You don't have to. In fact, I'll show you a legal text that says obtaining this kind of information about a competitor is a part of healthy competition. Or I know companies that have put in their ethical guidelines, I think it's a mistake, that we have to notify the competitor that we're seeking information about them in order for them to take reasonable precautions against us. I've seen this. you don't need to do that. That's the story I told you, David, when the CI head of the CI department at a very large company asked me to come and discuss that issue with their lawyers, and the company's general counsel, it's a Fortune 100 company, the company's general counsel and some of his staff members came to the meeting, and I was talking with them, and I couldn't get him to budge to think that there was, something wrong with that. And he told me that, I told him that, look, I think you're doing, if you're this conservative, I think you're doing a disservice to your company. And the only thing left to do is for you and I to debate the issue in front of your CEO, let him decide. So as I told you, that was turns out to be the last day I was ever allowed in that building again. But a few months later, he got some kind of parallel, I don't know, hiring move. And instead of the general counsel of the transnational company, he became the general counsel of one of the European offices. I never found out if that incident had anything to do with it.
Yep. Yeah. So do you want to talk a little bit about some of these, the restatement of torts here? Why don't you address this a little bit, with the group?
Okay. A restatement is not a legal binding document. It's a book written by legal scholars, and which tells you what you can basically expect in court, because they've reviewed all the issues, and it tells you what you can expect. So look at section 708. One who causes loss of business or occupation to another merely by engaging in a business or occupation in good faith is not liable to the other for the loss so caused, though he knows the loss will result. So I'm going to engage in business. I know that I'm convinced that I'm better than my competitor at it. I'm going to excel. The more I excel, the more he's harmed. Is it legal to harm someone? Well, there's no law that says don't harm anyone, right? But here we see in the
other than criminal law.
Well, there's no criminal law that says it shall be a crime to harm someone. The
wording is different.
Would have to be much more specific to what it is harm. How do you define harm? Criminal law has to be very clear, otherwise it could be declared unconstitutional. So here you're entitled to engage in your own business, knowing you're going to harm somebody else's business. And that's all right. And here you see underneath in section 757, it has the rationale for this, why you're allowed to do that. And it says the privilege to compete with others, which is what we read before, 708, includes a privilege to adopt their business methods, that sounds like CI, ideas or processes of manufacture, that's CI. Word otherwise, here's the reason. The first person in the field with a new process or idea would have a monopoly, which would tend to prevent competition. This privilege has some limitations, however. So the idea is you can't give yourself perpetual intellectual property protection by self-declaration. In other words, you either patent your idea, in which case the matter becomes public, but it expires in a while, 17 or plus years, or you keep the matter as a trade secret. But if you keep the matter as a trade secret, the trade secret will never expire, provided nobody else figures it out. If someone else figures it out, you lose your trade secret protection. So you have that decision to make. But the point of it is, if someone could declare that they have trade secret protection forever, the first person in the field with the new process would have a monopoly, which would tend to prevent competition. So doing business intelligence, competitive intelligence, would promote competition. The only issue you have to be aware of is if you're going after trade secrets, then you've got to make sure to use legal means in doing it. Let's go back to the other slide for a second. Look at the bottom paragraph. The rule stated in this section is limited by when the thing copied is a trade secret. And this is an important sentence. It is the employment of improper means to procure the secret rather than the mere copying or use, which is the basis of liability. So if you just copy it, how do you copy it? Let's say you're in the library and you figure it out, and now you have it, and they don't want you to have it, but you're in the library and you figured it out. I mean, this doesn't happen in America. Police officers walking around libraries and say, "Pardon me, are you trying to find a competitive advantage?" This doesn't happen. So if you figure it out on your own, then you're allowed to use it. The question is, what if you engage with the competitor or ask questions, which we'll speak to in more detail. Now,
and I want to move fairly quickly through this next part because we want to get to some of our key questions here as well.
Okay, now this is a model act that was passed by a legal association. It's been adopted in most states, almost all states. You can't use improper means, includes theft, bribery, inducement of a breach of duty to maintain secrecy, and so on. Okay, look at, then it says in 2C, if you received a trade secret and it was received with the knowledge that it had been acquired by mistake. Okay, but look at the comment. The type of accident or mistake that it refers to involves conduct by a person seeking relief that does not constitute a failure of efforts that are reasonable under the circumstances to maintain secrecy. So if they fail to maintain proper secrecy and you happen to find the document in the street, then it loses its trade secret protection.
So how about things, though, Richard, that aren't, normal everyday things that nobody would even think is a trade secret, right? So understanding a competitor's strategy, looking at their go-to-market approach, their pricing, their value proposition, their differentiators, uncovering what their manufacturing operations are, how many people they have worked there, how many lines, how much does it cost to make something? And, you're having conversations with people to piece together all these different areas, or you're finding some published information perhaps, but let's just say we're focusing on primary research, talking to people. Where's your view on capturing those type of things? I call you up and I want to understand about your manufacturing facility, and I ask you some questions about how many lines you have and what do you make there, and you tell me. Is there a concern with that?
Well, the only concern could be that the other company might make an issue of it, not that you actually have a legal problem. There's no section of law on the laws of talking to people. That doesn't exist. So as we've said before, and everybody knows this, if you call someone up and just say, this is who I am, I'm doing some research on your product or on your company, and can you answer the following questions? If the person says yes, then it's highly unlikely he's going to tell you something he's not supposed to say, because people know what they're not supposed to say. And they just don't disclose it because somebody asked a question.
So now let's get to the heart of what the topic is in our industry, right? And has been forever. The word that's on the top here, the misrepresentation word, right? So then you always have people saying, yeah, but I only told you because you told me you were X, right? You told me you're something other than who you were. You told me you were a customer or you were interested in becoming a customer. Or there are organizations that will hire MBA students and they will go and say that they are doing the project as a student, right? And people will talk to them. So what's your perception on that? Again, forget the ethical component of that right now. I'm not going to ask you to put the ethics aside, whether you should or shouldn't do that. But from a legal standpoint, what's your opinion on taking those actions? Does that constitute misrepresentation?
Okay, I'll answer the question, but I want to bring up something you said in the beginning. There are two answers. There's what I think, and there's what your company policy is. So you have to do what your company policy is. What I'm doing is giving people a background as to how the law works. And you have several advantages in knowing that, because first of all, it's always good to be educated. Secondly, You'll be more able to talk to your lawyer if you understand the basics. And third, you might think that your lawyer is being too conservative, and you'll be able to converse with him. But the bottom line is, you do. When I speak at companies, I always ask for someone from the legal department to be there to know what I'm saying to them. They always say, hey, this is what I think the law is, but your policy is what you have to abide by. Okay. So now, regarding your question, let's say George is a student, real student, and he calls up someone at a company and says, I'm a student, I'm interested in researching your product or your company. Here are some questions. And the person at the company answers the questions. Okay, no problem with that. What if you're a competitive intelligence person and you do the same thing? I call up and say, my name is George, and I'm interested in knowing about your product. And that person will tell you the same thing that he would tell anyone. You know, if you just called up and say, I'm considering buying your product, what can you tell me about it? And what he's going to say to the caller won't contain confidential information, right? Under those circumstances, even misrepresenting yourself by calling yourself a student, that misrepresentation did not induce a breach in the person's confidentiality. So the misrepresentation did not induce a breach. The question elicited an answer. And if the person who received the call later found out that you're not George, you're a competitor or a CI person, and you lied, they'll be angry. But that itself isn't a violation of law, because first you can expect that he didn't say anything confidential. And secondly, the misrepresentation is not what caused him to answer the question. I mean, a great example of a misrepresentation that induced a breach, and this is a true story, someone calls someone who this was not a CI person who did this. Someone called someone at a company who had access to confidential information, saying, I'm calling from the CEO's office, and he now wants you to send documents XYZ that are confidential to this address. He needs it done right away. And that person complied, because who's not going to listen to what the CEO's office said? That kind of a trick or misrepresentation induced the person to breach their duty of confidentiality. Or another true, real case, George was working at company A, and companies A and B had an NDA between them. They were working on a joint venture. George left company A and called company B, asking for some information under that NDA for a company he was no longer working at. And he didn't tell them that he was no longer working at the company. Company sent it to George, found out later that George tricked them by making them think that he was working for company A, where they had this confidentiality agreement. That's an example of an inducement, a misrepresentation that induces a breach.
And as you said before, that it doesn't mean that the company that you're targeting or researching on still might not be happy about something and want to take action, right? I mean, that could happen. It really doesn't in the CI world, but it could. So can you talk a little bit, though, about how risky from a legal standpoint is CI? You know, any attorney that might be watching this, or that anybody here might share with their corporate counsel, in your opinion, how risky, from a legal standpoint, is CI really?
Well, from a legal doctrine standpoint, it's not risky, because what I've explained, but also companies will hire private investigators to do certain things and use all the tricks that they know how to do, collecting garbage and surveillance and pretext calls, and they know how to do that within the law. It's just that the private investigator industry developed differently than the competitive intelligence. The competitive intelligence industry was started by database specialists and librarians, and they did fine obtaining what they needed through public information, whether it was in libraries or whether it was online. So they didn't have no tolerance for this sort of thing, all these, questionable things. But companies will hire private investigators to do certain things, not necessarily for a competitive intelligence purpose. The FBI told us that our company pollutes. The FBI told us that economic terrorists are going to damage our facility. We have to investigate to see what they're going to do, or someone stole our product, or trade secret, or is counterfeiting a product. They'll do all of those things. But when they do competitive intelligence, they have to abide by the same law that applies to CI professionals. So they abide by the law. Right? Most of the time when you see people getting into trouble, legal trouble, by crossing the line, they're not CI professionals or private investigators.
Or there's oftentimes an NDA violation that comes into play, right? Where there aren't really legal cases that are so significant that it affects our industry, where people should change what they're doing, that you're aware of. Are there?
For the first 15 years of my involvement, starting in 97, I think, I was able to say that there have been no legal cases against CI firms. Today, I could say I know of 2. That's it in the entire.
But the unique situation with those weren't because of the things we're talking about. There was something else that happened.
The CI firms, in my humble opinion, the CI firms who were sued should not have been sued. And the law firms of the major company that sued them are stretching the bounds of what could be called appropriate legal arguments.
And what's interesting is oftentimes those companies that are irritated or bothered or mad because someone's doing CI on them, they often are doing CI themselves.
I've said
others,
that,
right?
I've said that in a mediation in one of these cases, where the opposing lawyer, one of the opposing lawyers said, "How are you going to look if I explain that your client did XYZ?" And then I said to him, "How are you going to look when I demonstrate that the company you represent does the same thing?" Yeah. And I caught him off guard, but that's what.
So I'm going to share with you some rapid fire questions here that I know a lot of the folks on the call are also interested in. If we have time, we'll take a look and see if there's questions in the chat. But again, we're not talking about the legal, the ethical element of it. We want to hear the legal element. So you're in a restaurant, you overhear a conversation taking place in the booth next to you, and they're talking about some new innovation. It happens to be your competitor. So there are some that would say, "Well, you know what? I need to walk away from that booth." There are others that say, "I have to tap them on the shoulder and tell, shh, keep it down because I work with your competition, and I can hear you." And there's others that will pull up a chair and start taking notes, right? So from a legal standpoint, if I on the bus or wherever, and somebody's boasting about some new things they're developing, can I listen? Can I use it?
Yeah, those different examples you gave me are would be like ethical ways of handling it. But right. If somebody, you don't have to protect people from their own stupidity. Like, there's no law that says that. I've seen articles that say that, written by journalists, but that's not true. You don't have to protect people from their own stupidity. If people are just speaking and don't realize or care that there's somebody who might overhear them, that's their problem. But
again to be fair too, again, just make sure you adhere to your company's code of conduct, though, because right. If there's a specific language in your code of conduct that says, "Hey, if you're hearing that, you need to go sit somewhere else," and go sit somewhere else.
If your company policy says if you overhear this, then you should walk away, then that's what you're supposed to do.
Richard, why do you think that attorneys sometimes now have gotten more conservative about, like, they don't want you to call competitors directly, or in some cases they want you to start the conversation with, hey, listen, I don't want you to tell me any confidential information. They actually want you to start the conversation that way.
Yeah.
Why do you think companies, attorneys have gotten that risk averse, especially in some industries or some companies, when their product may actually really harm people, and they're okay with that, but they don't want you talking to the competitors?
Yeah. Well, lawyers are generally conservative. Generally, I do know some lawyers at certain companies that will tell their CI people, if it's legal, do it, and if you get into trouble, we'll handle it. Right? That's not common, but I've seen this. But lawyers are generally conservative, not because they're want to cause you trouble. Lawyers are conservative because they're concerned about what the other side's lawyer might do. So we have this whole dynamic of lawyers not letting employees do certain things, not because it's not legal, because out of a certain policy, or because they're concerned the other company's lawyer might make an issue of it. And that's a company's decision. I don't tell companies how to make a decision, but for something has happened in the last couple of years that I've been hearing that lawyers are becoming more and more conservative. And I don't know why it's happening, but it is happening.
So how important is it that a CI professional form a strategic alliance, with their legal department? I think you and Jan Herring wrote an article many years ago on that exact topic. So briefly, just, what should happen? How do you go about doing that?
I think the article we wrote was in 2004, but I think it's very important because in all likelihood, the lawyers aren't going to understand CI to the fullest. And the more a CI professional can explain what they're doing, the better the lawyers will understand what it is they're doing. Now, companies have their own considerations as to where they want to draw the line when it comes to guidelines, corporate guidelines. And they may very well understand that X is legal, but we just don't want you to do it for whatever reason they have. And there are a lot of considerations that go into it. But there are companies that have gone too far, in my opinion. And I told you about the meeting I had with that general counsel and his staff. And one of the things he wanted his company to do is tell the competitors they should take reasonable precautions because we're seeking information about you.
So there was a question posed about, are there guidelines on getting information on a competitor via former employees of that company that now work for you?
Guidelines, sure. Every company should. I expect companies have guidelines on those. So you can talk to former employees about their prior business, their prior work or prior employment, but the former employee is still bound by if he has confidential information or trade secret information, the former employee is still bound by his NDA that he signed with the former company. So it is not a good idea to ask a former employee to tell you to violate his NDA with his former company.
And that even starts at the interview process, right? That even starts during the job interview process, right? To making sure you're not putting them in that position. How about this? There's another comment around a person that works in the CI software industry and works in CI for software. And a lot of those terms of service of software say that you can't use your account for competitive research, right? Or other variations of that. How enforceable in your mind are those kind of provisions, that, have terms that say, you can't use your account being a customer of ours to get competitive research on us?
Well, the real answer is you've got to read the precise language in there. But in general, explain to me what kind of online platform are they talking about that has this?
Well, I think it's just any software tool that if you're, that if they have terms in their agreement that says you can't use your account with us buying our software, it's not a CI software necessarily, it's just any kind of software tool that says you can't use, your account with us to get information, competitive research on us.
Well, look, the general rule is if you sign an agreement, you have to abide by it, right? And
so that might be something if it's in there that you have somebody strike out or work it out or not.
Yeah,
just
that's
not
a
put yourself at that
question
risk.
ask your lawyer.
Okay.
Generally you have to abide by what you sign, but here's something that lawyers know, that not everything you sign in an agreement or in a contract is enforceable in court, right? So you've got to you have to know contract law and weigh the various considerations. And that's something that in real life that you should ask your own general counsel about.
You had mentioned that in the reality, you've only know of 2 cases that involve CI, and it's questionable whether it really was anything to do with CI or just the attorneys.
I don't have a question. It's not questionable in my eyes, and I think both these cases were.
So the reality is, and this is a question that was posed in the chat. The reality is that we've been around 33 years. We haven't even so much as gotten a cease and desist letter. So, the question is, well, how often are companies sued for CI? There have been some cases over the years, whether or not it was directly because of CI or some other action that was taken that might have triggered it, but it could have been under the guise or somehow be related to CI. But it's an incredibly small number of situations where CI firms or a company gets sued directly because of CI. Couple of other quick things. Unless I'm wrong in saying that, Richard.
No, you're right. In fact, let me make this comment. How many members does Skip have generally?
Don't really know these days. I think depends on who you ask. Probably between 1,000 and 3,000 somewhere.
Yeah, I remember they're in the lower thousands. So, traditionally Skip had 3,000 or 4,000, sometimes a little more, sometimes a little less. Going back the last 25 years. How many licensed private investigators are there in America? 70,000, right? And licensed private investigators generally know the law better than anyone else because a lot of them are former law enforcement people. Number 2, a lot of them work for law firms, and law firms don't want them to do anything illegal on their behalf. Number 3, they're in a regulated business because they're licensed. If they violate their certain laws, they can jeopardize their license or be sanctioned some other way, punished some other way. And how many private investigators are sued? Very few. It happens. It does happen that some go too far, but it's not that common. Somewhere in America, some PI is getting sued for something, but it's not that common.
So handful more questions for you. So this is one again. I got a few of mine, but I want to address one more that was up on the chat here. So these days, companies or third-party CI firms are paying expert network recruiting firms. So there's different firms out there, Richard, that actually are identifying and recruiting competitors, either current or ex-employees for interviews, right? And then they charge a ridiculous amount of money to have those interviews. But the question, because during these interviews, things like pricing questions or questions about manufacturing costs or other questions might appear to reveal, according to this question, reveal proprietary questions, right? That are often asked and answered. So the ex-employer, the current employer, the competitor is paid an honorarium for their time, right? Yeah. And the question is that legal? So, these companies obviously around their business, but in your legal opinion, is it legal for them to be able to recruit people, have them be part of their panel, essentially, pay them an honorarium for their time, and then they might be answering questions that could be violating, or sharing confidential information?
Well, the idea of a company whose business it is to develop networks of former employees of various companies or former subcontractors of various, that happens across America. That's nothing. It's not an illegal activity. but you still have to be careful that if the person violates his duty of confidentiality, his NDA, you got to be careful with that. So it goes back to the same issue.
So I think we oftentimes when we're having those interviews, if someone even hints or suggests that, hey, I'm not sure if I should be telling you this, we always tell them, then don't.
Right,
Don't tell me.
exactly.
And then if they tell me anyway, then I'm going to assume it's not confidential
Right.
because I told you not to tell me.
Yeah, in real life, despite all the talk and all the concern and all the news articles, in real life, it's not common for CI firms to actually acquire the real thing, the real trade secret. You generally acquire useful information that you were able to put together by being smart that the other company may not have wanted you to know it. But to actually acquire, if you look, it's pretty settled that if the trade secret information is discarded, left in the street or whatever, you pick it up, it loses its trade secret protection. In real life, if that really happens, which I've never heard of any case, in real life, you're going to be so nervous that you have this document, you're going to be, however much you hate your lawyer, you're going to be running into his office and begging him to take the responsibility away from you to decide what to do with it. And what will happen is your lawyer will call the other company's lawyer, say, we found it in the street and we're returning it and not using it. That's what's going to happen.
It's interesting. Many years ago, probably over 15 years ago, we were doing research. We actually had someone send us blueprints for a manufacturing facility, right? It kind of got that, said, I don't really think we should be having this, rolled it up and sent it back. Now, the interesting thing, about 3 months later, those exact plans were in the zoning office for permits, right? So then it became publicly available, right? But there's certain things you have to know that you shouldn't possess,
Right.
You know, and then, you know, you have to be the barrier between what you ultimately share then with the client, right? You know, if you're a CI provider, to not put them at risk as well. That's one of the reasons you have a firm like us. You have that buffer, right? A little bit. Let me ask you this in terms of what's your take on corporate counsel that is prohibiting either their employees or even the outside third-party firms they might use to talking with competitors' employees directly, or even former employees that aren't there for, say, 6 months or 12 months. You know, what's your take on companies that have gotten that restrictive?
It's been reasonably common for companies not to want their employees to contact a competitor's employees or a competitor's former employees for policy reasons. They just don't feel comfortable with it. That's why there are CI firms. So they hire the CI firms traditionally, and the CI firm will say, hello, my name is, here's my name. I work for this company. We're doing research on this product.
But increasingly, they've been extending that policy then even to
CI firms.
Yeah.
I don't know why. I don't know why that's happening, because there's nothing happening in the courts that has been making this sort of activity more legally risky.
So it's a comfort level, really, and trying to think they're minimizing risk because they're not getting something now directly from a competitor.
Yeah,
you're figuring it out through other channels.
Yeah, I don't know why it's been increasing, but I've noticed that.
Okay, how about what do you think then ultimately with companies doing that? What is it? You being an attorney, what is it that they're most afraid of? Attorneys that have those really restrictive guidelines in place from a legal standpoint.
Oh, companies are the attorneys are afraid of their company getting sued. It's their job to make sure their company gets sued or doesn't do anything that looks bad in the business media, and that's what we're afraid of. And just because you did everything legally doesn't mean that the competitor is going to agree with it. And I've seen, look, nearly the vast majority of trade secret cases that go to court, actual cases, deal with two issues. One of two issues. Either a former employee left taking confidential or trade secret information with him and breached his NDA, or two companies were doing a joint venture and whatever went wrong, the venture, project ended, and somehow all of a sudden one of the companies is using the trade secrets it learned about the other through their NDA in the joint venture. Those are most of the trade secret cases in American courts. Once in a while, you'll have somebody trying to, do something clever, and they obtain trade secrets by doing something illegal. But those are not CI professionals, and they're rarely private investigators. I mean, sometimes, but not often.
Sure. So a few more questions for you here before we share some closing calls to action for the participants. Is there's a question posed around honorariums, and again, these are not unique to CI. I mean, market research firms use honorariums all the time, right, for survey type work and others. But does a payment of an honorarium for a source's time constitute an inducement to violate confidentiality, or does it go back again to the fact that what you're asking for, what you're getting, isn't confidential to begin with, right? But let's just say it might be they get an honorarium and they now are sharing something. Does that constitute an inducement, paying an honorarium for someone's time?
Put it this way, the company that does that is not trying to induce a breach of confidentiality. You pay someone $200 for their time, they're not going to, under normal people are not going to disclose trade secrets for $200. So this is standard. These things happen all across America, not only regarding CI or sensitive information, but just marketing experiences. How is it dealing with this company?
Yep. Great, thank you. Thank you. Let me sorry to interrupt, but I just want to be able to get to a couple of these other questions. So a rogue employee, disgruntled employee leaves, and they either post on Glassdoor or some other site information, or they talk to you and they tell you things that are confidential, and they know it. And in fact, it is confidential. They're not allowed to share it, but they're pissed off at their employer and they tell you. What's the legal position on that? I mean, can I use something that some rogue or disgruntled employee shares with me that is knowingly, to them anyway, perceived as confidential?
No, the answer is no, because look, I walk up to you and say, I work at your competitor, I'm angry at my company and I want to hurt them. So here are some trade secrets. You can use them and hurt my company. You can't use them because you know that the person is doing that through a violation.
Addictive,
yeah. So you didn't induce him. You didn't do anything, but you know that you're acquiring it from someone who didn't have the authority to give it to you.
So now if you got that same information, but through your normal research approaches and everything else, then it's fair game.
If you got that, if you figured out that information through, your routine techniques, right, that's fair game because you figured it out on your own and you didn't use improper means.
So let me, if I may, because we have just a few minutes left, I'm going to reshare my screen again here to just talk about a couple final calls to action here. And then I want you to think about this question, Richard, and that is, again, ultimately share with the group how you think you could help their corporate counsel or any corporate counsel that might be on this call, watching this. But first, everybody that's watching, form that strategic alliance with your legal team. Some may be, they're there to help you. They really are. What I found, they're to help you gain as much as an advantage as you can, even if they're conservative, right? But you'd have to follow the guidelines, whatever the rules are ethically and legally of your company. Make sure you're following them. Make sure that any outside firm you use follows it. It's just not worth the risk to get a piece of information by violating those there's other ways to figure out information. Again, make sure others in your company are aware of your code of conduct. Sometimes people who aren't CI professionals are doing CI work out in the field and other places. So make sure they're aware. Do some lunch and learns with people. And again, get your legal team to know Richard. I'm telling you, he will help you to advance. Maybe not all of them. Some might tell him to get lost, like he said with his other example. But most will be open because they'll have another lawyer now to get another perspective on on the law in this particular area. So before we wrap up with Richard giving a final thought, just got a final poll question. Did you guys get value from today? Did you learn something new? Did you find this session worth your time to be here today? I hope you walk away with some different understandings or affirmations of what you already believe to be true along the way here. So we'll give you another couple seconds on this one. So let's wait another 10 seconds for folks to respond to the survey on screens. Whitman, let's go ahead and close that out. We have 70+%. Good. So everybody gained value if we respond. That's great to hear. So thank you for that. And Richard, I really appreciate you being here with us today. We value your opinion. You and I go way back, 25 years. These are all the same. Isn't it crazy? They're same conversations.
Same questions, same issues
that we had 20 years ago.
Yeah, same issues. Nothing has changed.
So in your opinion, how can you best help the folks that are on this call to get their legal team, especially if they're an early stage startup, to have conversation with their legal team?
Well, the first thing I suggest is go on my website, look at the publications page, go to the CI section, read the article I wrote in 1998 and read the article I wrote in 2011. And you'll gain a lot of understanding of this issue from those two articles. And then self-promotion is not so easy when you're giving a webinar, but you've done it for me. So
well, I could tell you, if you guys get the chance, I would highly recommend, you get your legal folks to get in touch with Richard. If nothing else, just to gain better understanding, to review your current policies and guidelines, to foster some dialogue, lawyer to lawyer. It's made a real difference. So again, with that said, Richard, thank you for your time today and for all your knowledge that you shared with everybody. We really value your opinions. And again, keep in mind, none of today was legal advice to anybody. These were our perspectives and opinions. Always follow the guidelines of your own organization. So with that said, thank you everybody for being here, and we hope you have a great remainder of your day. Take care.
Thank you.